Welcome back, everybody. Todd Vandermeide, former NRA contract lobbyist, Illinois gun law guru. So here we go again, another edition of Freedom Steel for you guys. What this video is going to be about is to try to help explain and sort out the various actions that are going on within the courts. Get a lot of questions about this because of the emergency order, because of the Seventh Circuit briefing schedule. All this stuff has led to some confusion about the multiple parallel tracks that are going on with our cases. So, we are going to go in there. But first, I want to give a shout out to Mark Gasper. Came home the other day. There was a big package there. The wife thought I was ordering stuff from Amazon Prime again. No, that did not happen. I got this wonderful little tumbler here, a cat tumbler that we are going to be putting to use tonight as we work through these videos. Got a bunch of Caterpillar hats. Mark sent me this limited Cat D11 diecast model. What Mark doesn't know is that I have a fairly extensive collection of diecast heavy equipment from being an operating engineer. So it'll fit right in. Thank you very much for your generosity. For those of you guys that continue to send me bottles of booze and that because it's the jet fuel that keeps this thing running, we're putting it to use tonight. So yes, it is the jet fuel that helps fuel this channel, much like the invariable A10 Warthog. So with that, here's where we are. We had the district court in Southern Illinois consolidate 4 cases. The lead case now called Barnett. I'm involved with the FFL Illinois case. So you have that at the district court. The district court issued an injunction. Okay. So now we had Freedom Week. And then the state ran to the district court and they said, hey, we need you to stay your ruling. And the judge issued his original injunction Friday afternoon. They ran to court and filed at just before midnight that night. And it was in front of the judge on Monday. Monday, the district court judge, St. Stephen, sat there and said, I'm going to give the plaintiffs a week to reply. The state did not like that. And so the state filed what's called a Rule 8 emergency motion for a stay of the injunction. Now, according to all the attorneys that I've talked to, both those involved with the case, those not involved with the case, this was erroneous and wrong. So we now have the district court case over here, and then we have the emergency appeal for a stay at the 7th Court of Appeals. I'm going to abbreviate that as COA here. So we have the emergency request for the stay, which was issued by Judge Easterbrook as a single judge, not the panel. Judge Easterbrook then said, hey, you want to respond, you ought to say something about Friedman and Wilson. Okay, that was done today. At the same time, the state appealed the injunction and had filed a notice of appeal with the district court that they were going to appeal the issuance of the injunction. So now you have 2 parallel tracks at the Court of Appeals. You have the emergency stay, and then you have the objection and appeal of the issuing of the injunction. Those two are working themselves together. You also have the Barnett case, which is NSSF and NRA, and FFL Illinois, filing briefs at the Supreme Court as amici in support of Naperville and the Beavis case All right, so I call that case Naperville because it's dealing with the Naperville ordinance. Niagara bootstrapped in the state stuff, which I don't think they did in a smart way, but we're there. So the Barnett people, Aaron Murphy and Paul Clement, entered into an amici brief at the Supreme Court supporting an injunction for Naperville and possibly for the state of Illinois. FFL Illinois entered into an amici brief, much the same thing. And we argued our right to repair and a couple other things. The issue is to get those issues and further enlighten the court about all the actions that are going on in the courts below and what's going on here. So the Supreme Court does not necessarily, it's not part of our case right now. Why? The why is because the Naperville case was denied their request for an injunction pending appeal by the appellate court. It wasn't a single judge, looked like it was unsigned by a panel. That was it. So now we have all that going on. And that's why Naperville is the case at the Supreme Court. We are simply trying to support that and raise awareness and enlighten the court about what's going on where judges below continue to refuse to follow Heller, McDonald, Kitano, and New York. We are not formally in front of the Supreme Court. We have simply made friend of the court arguments to the court. So, and then within our own case at the Court of Appeals, there's a request on briefings due this week about whether or not Herrera and our cases and other cases in the Northern District should be consolidated for the purposes of judicial economy. Now, it can take one of several forms. One, they can consolidate them, appoint a lead case. They could augment all of them and say, you know what, here's the briefing schedule. We're going to hear all these cases on the same day, which is what the Second District Court of Appeals did with like 5 challenges to the New York carry law and such. And they did all that. So we will see what happens when those briefs are filed. There were briefs filed today to Judge Easterbrook about why he got things wrong, with Aaron Murphy and Paul Clement taking the lead on the Friedman stuff in a 29-page brief. And FFL Illinois filed a shorter brief talking about the other irreparable harms that are being happened, he foisted upon gun dealers and the other issues that lay in there. So that's what's going on. Now, the state cases, they have no bearing on our federal 2A claims. The state cases are all dealing with procedural 14th Amendment and other claims within state court. None of them filed a 2A claim. So they have no real bearing. Now, whether or not the Supreme Court agrees with their case, throws their case out, it may, and what that does with the TROs and all that stuff, we'll see. But that's going to take, I don't think they have orals in the Calkins case until next week. And from there, I think it'll be 2 weeks, and they'll issue a decision of some sort, and we'll go from there. So with all that, that's kind of in a nutshell what it looks like with all the moving pieces is just our cases right now. And so I hope this kind of clarifies things because we've got 2 issues. We've got the emergency stay that was under Rule 8 that was issued by Judge Easterbrook. Then we got the whole panel issues of the injunction in and of itself, for the consolidated cases, both at the 7th Circuit Court of Appeals and everything else. So it all it gets muddied. It gets confusing at times, but that's the long and the short of where we really are and what's going on right now. And more stuff was filed today. We'll get to that in another video, just trying to bring you guys up to speed so everybody knows. So once again, guys, continue to support the efforts. We've broken 8,000 subscribers here at the channel. We really appreciate all your help in getting the word out. Continue to like, comment, subscribe, post the link to this video on your social media sites and forums and places you hang out at. Really appreciate all that. It helps to get the word out, and we'll keep working with the jet fuel here to turn out some more content. So as always, frag out.